materials characterization, and he was a very top student in the class, and was so impressed with him, and have followed a little bit about what he's done since that time. He ended up as an undergraduate working for Bard Access, which is now part of Benton Dickinson, and working on polymer materials. And he decided to go to law school, attended the University of Utah, and while he was attending the University of Utah, he started working for Trask Britt. And Bill Britt was a good friend of Ron Gordon here in the department, and it's been a really great law firm. Jeff has done well. He's succeeded at the firm. He has had a lot of recognition both as a young lawyer and now as the managing shareholder, which means that he's in charge of the 30 patent attorneys who work for this firm. He's been named to Best Lawyers for the last 7 years. He was awarded by Super Lawyers 2 years, and in 1921 was the Salt Lake City Patent Attorney of the Year. Jeff has done lots of different patents, but he loves work that he's done in hard materials, both diamond and other super hard materials. He's also worked in semiconductors, circuit design, nanomaterials, MEMS, and he's very gracious to come and spend his time with us today. It's not often that you get free time from any lawyer, but it's a delight to have him here. He loves to be outdoors, he loves to ski, he loves to mountain bike. He and his wife are the parents of 3 children, 3 teenagers, and he looks exactly the same as he looked when he was a student. He hasn't aged a bit. So let's welcome Jeff Gunn.
Can you hear me all right? Thanks for having me. Thanks for coming. I take any chance to get back on campus. I love my time up here. Favorite era of my life by far. Dr. Cutler wrote me a letter of recommendation law school. I still have that in my drawer at my desk drawer at work. Okay, so when Dr. Cutler told me we were going to put this on the internet, I said, that's fine. You just have to listen to my silly legal disclaimers here. This is not legal advice. Get a lawyer. Let's see, this is not legal. If I can get the presentation mode going. Sorry about that. Okay, here we go. And hold on a minute, sorry. Okay. I'll send you this by email. You can circulate it to whoever wants. So just to give you an idea, we talk about intellectual property. There are different segments of intellectual property. These are all the different types of intellectual property. These are all human constructs, not real things. We just decided that we should make them up and treat them certain ways because it's good for society. We're going to talk today about utility patents, maybe a little bit about design patents. So where does this all come from? This is the Constitution. When the U.S. was founded, founding fathers wrote this Constitution. And you can't really read it, but this is Section 8 of Article 1. And there's one sentence in here, right here. You can read it if you look really close. But what it says is this. The Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the Founding Fathers gave Congress the power to do this. Congress, over the years, has written all this code, these laws about patent law. It's voluminous at this point. But a little bit of history, why did they put that in there? What were the Founding Fathers thinking about? Well, it stems from England. And in the 1600s, the English Parliament passed this 1623 Statute of Monopolies. And what was going on at the time in England was the Crown was just granting patents, monopolies, to their buddies and excluding everybody else. Parliament decided that wasn't fair, we're not going to do that, so they banned those monopolies with one exception, which was this exception, providing that the statute contained an exception providing that the general prohibition on monopolies did not extend to letters patents for 14 years for basically new inventions. So that was on their minds when they put this in the Constitution. What's the rationale for doing this? Why should we do this? The idea is that it's a quid pro quo. Okay, that translates something for something. The quid is the inventor discloses to the public, hey, I figured something out. I got a new invention. This is great. Great. We're going to tell it to everybody so everybody knows about it. They get a limited monopoly for currently 20 years from the filing date of the patent application in exchange for telling the world about it. And at the end of the patent term, it goes into the public domain. It's free for anybody to use. Sounds like a pretty good idea. I got a link here. I couldn't get connected to the internet. I was going to show you, if you go to the House's website, the U.S. House of Representatives, they have all the U.S. code on there. I was going to show you where the patent law is embedded in there, but you guys can Google that and see it. But the point is, at this point, we've got literally books of patent laws. So this is an example of a patent. I want to just kind of orient by the show of hands, who has seen a patent before? Who's looked at one? Most of you. Okay, good. Let's see here. Don't know why I can't get this to show my whole screen. I have to pull out of here to see this. Okay, so this is one of Dr. Cutler's patents. But every patent application, the rules, the laws specify what a patent application is supposed to look like. They all have, I'm going to pull down, this front page is kind of a bibliographic cover sheet. But every patent application has the same sections. They have drawings. Then they have a background. The background includes the field of the invention, discusses the prior art. There's a description of the figures section. There's a summary of the invention. That's an optional section. Description of the drawings. And then there's a detailed description. The detailed description refers to the figures, describes what the invention is. And then the only part of the patent that really matters, that anybody cares about, well, I shouldn't say it that way, but at the very end of the patent, there are claims. And here you can see what is claimed is. And this is a method of forming a sintered ceramic body comprising predominantly by weight silicon carbide. And then it has these steps, and these steps are recited. And you can have really any number of claims. You pay fees for excess claims in excess of 20, but there's independent claims and dependent claims. Okay, claim 1 is an independent claim because it doesn't depend from any other claim. Here you can see 15, the method of claim 1, further comprising. Okay, so you go into this process of getting the patent, you think your invention's this big, you draft claims to an invention this big, and during examination, the examiner's looking for prior art, and you might have to narrow your claims. And I'll speak to these dependent claims a little bit later, but dependent claims are narrower than the independent claims. The independent claims are the broadest claims, okay? And when you get into a lawsuit, the defendant is challenging the validity of the claims. So during a patent infringement lawsuit, there's allegations of infringement of the claims, and then the defendant challenges the validity of the claims. And they get ruled on claim by claim, and as long as there's one claim that's valid and infringed, then the whole patent is infringed. Does that make sense? So it's very common, it's a misconception. People who don't know anything about patents, they'll see a product or they'll hear that there's a patent, and they'll go look at the drawings, right? And they look at the description, they go, oh yeah, they got a patent on this is covered. The reality is, you have to look at the claims and see what the claims say, because there could have been prior art all over that invention. And to get the patent granted, they may have had to narrow their claim scope from this to this, right? And so whether something is patented or not is you need to talk to a patent attorney and let them look at the claims. It's not black and white, it's very gray. Any questions about that? Okay. So what is patentable? The reality is, the better question is what is not patentable, because you'd be surprised at what is patentable, okay? Whoever invents or discovers, this is in the US Code, this is in the statute, a new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore subject to the conditions and requirements of the code. So, new materials, new devices, new machines. People talk about software, right? You can't patent software in and of itself, but you can patent a machine that has the software on it that is now technically a new machine because it's doing something that nobody's ever done before. Okay, there's tricks that patent attorneys play to get patent protection coverage for things that typically are not patentable. The code does not exclude any patentable subject matter. It just has this positive recitation. You can patent all this stuff. But there are some exceptions that have come through the courts, okay, and this is kind of where law comes into play. Congress passes the statutes and the courts interpret them, okay, so there's been cases where people have said, well, this shouldn't be patentable, and they argue it up to the Supreme Court. The Supreme Court has issued rulings interpreting the statute, and the Supreme Court has said you can't patent abstract ideas, laws of nature, and natural phenomena. There's a very famous case from right here in Salt Lake City with Myriad Genetics. They had patented segments of DNA, right? They had identified genes in DNA at specific locations, and then you can't patent natural phenomena, right? Natural substances. But what they argued is, well, we took something that was in nature and we isolated it, and this isolated component of DNA is not found in nature, and they convinced the patent office to give them that patent, and then they started suing people, and it got argued all the way up to the Supreme Court. The Supreme Court overturned it and said, no, this is a natural phenomena. Okay, so you have a new invention. Is it patentable? This is in the code. There's a two-step process to determine whether a patent application, a claim, is patentable. First, the question is it novel? Okay? And by the way, there's patent offices all around the world, and they all apply a very similar analysis. They're slightly different in every country, but they all have this two-step, novelty and then what we call obviousness. But Section 102 is the novelty requirement, and it says you're entitled to a patent unless it was patented, described in a printed publication, in public use, on sale, or otherwise available to the public before the filing date of your patent application. Okay, so what does that mean? It means that if your claim reads on something that's found in a single document or in a single device, then your claim is anticipated by that prior art, okay? So you weren't the first person to come up with this invention in its entirety. What happens most of the time is, yeah, we can draft, you have a novel invention, it's novel, you can't find the exact same thing in the prior art, right? It's different in some way. Maybe it's a small way, maybe it's different in a big way. Okay, the next section of the code, 103, says you can't get a patent, even if it's novel, if the differences between your invention and the prior art would have been obvious to a person of ordinary skill in the art. Okay, now it's funny. When I was in engineering, I loved engineering school. It's black and white. I remember walking out of tests, and I knew how I did. I knew which answers I got wrong. You go to law school, it is not black and white. It is very, very gray. Everything's gray. Everything's an argument. And this is a very gray area of the law, right? What does it mean to be obvious? Who decides whether it's obvious to a person of ordinary skill in the art? Well, the examiner does, right? There are examiners at the patent office who've made it their life goal not to grant patents ever, and there are other examiners who are asleep at the wheel just cranking out patents. And the law actually changed right when I'm going to speak to this a little bit. There were major overhauls to the code. And when I first started practicing, the Federal Circuit had established a much more black and white test for this obviousness inquiry. It was much more predictable to tell your client, okay, this is novel. Is it obvious in view of the prior art? I could predict fairly well whether the patent office would say it was obvious. But the Supreme Court overturned the Federal Circuit and basically said, no, this is a case-by-case determination. It's up to the judges. And it's become very, very murky. And so now when clients are asking me, is this patentable? It's very hard to advise your clients. And you say, it's novel, but is the patent office going to determine that it's obvious? It's very, very hard to predict that. Okay. So you've got your patent. What is the patent right? What does it allow you to do? Anybody?
So with a patent right, you can actually sue other people for infringing?
You can sue other people infringing. That's true.
Prohibits others from practicing what you do.
Yes. And the key here is others, right? Every patent shall contain short title and grant to the patentee the right to exclude others from making, using, offering for sale, or selling the invention in the United States. Okay? What does that mean? Does it give you the right to use your invention? If you have a patent on invention, do you have the right to use it? The answer is maybe, right? Because you, in using your invention, making, selling, using your invention, you could be infringing somebody's earlier patent, okay? And they can exclude you from falling within the scope of their claims. So the example that I used to explain to people is, let's assume you invent the car, and you invent a car. You get a patent to a car. And in your detailed description, you describe a car with an engine and a manual transmission, right? But you were the first person to make a car, so your claim is to the car. And you just disclosed a manual transmission. Somebody comes along and invents the automatic transmission, okay? They claim a car with an automatic transmission. They go to sell it, they get sued by the earlier person with the patent to the car, okay? And so essentially, the automatic transmission is locked up until the parties figure out how to take it to commerce, and they have to cross-license their patents, and pay royalties, and work out a deal to get a license to the earlier dominant patent so that they can commercialize their later improvement. So just because you have a patent doesn't mean you can use that invention. Yes?
Is this a presentation where we should wait for questions at the end, or can I ask?
I was told you can ask a question. I should just repeat the question, so remind me if I don't repeat the question.
So what kinds of international law protects? Because in this slide, it looks like this is all very much pertaining to the United States.
why can't I just take a patent and bring it to a country where a workforce might be better utilized to go into a process or something?
So the question was about international patents. And the reality is, all the patent offices in the world are very similar, right? Because we have international treaties, right? Their citizens want U.S. patents. So our government says, okay, well, if you want a patent for your citizen in our country, that's fine, but you've got to give our citizens patents in your countries too, and the patent systems have to be comparable, apples to apples, right? So all the developed countries in the world have subscribed to these treaties, and there's several of them that kind of homogenize the laws around the world. But there is no such thing as an international patent, okay? If you want a patent, you have to go to every patent office where you want protection and apply for and get a patent. That being said, and I wasn't prepared, I don't want to get off on a topic. No, it's fine. We could talk about international patents all day. There is an international patent organization that was created by treaties and funded by all these countries. It's called WIPO. It's in Geneva, Switzerland. It's the World Intellectual Property Office. And what these treaties say is you can file a patent application at WIPO, and they'll do one round of examination. They'll do more if you want, but it's not required. And then they'll issue a report on patentability. We think that the invention is patentable, or we think it's not patentable, and here's the prior art. And then you can take that international application and go to the various countries and move it into those jurisdictions with the hope that your examination is shortened. So, but the reality is, and I'm going to talk about the economics here, getting a US patent is expensive. If you want international protection, it goes exponential. So, and this is important for later, I want to talk about the economics of this because it's important for our discussion a little bit down the road. But what does it cost to get a patent application, okay? You take your invention to a patent attorney, we have what's called an inventor interview. We go over the drawings, we go over their description, how it's different from the prior art, and then the patent attorney will draft that patent application. It's just a long Word document. We prepare the drawings. We have draftsmen that we use. All they do all day is prepare patent drawings. And it's going to cost you $5,000 to $15,000 to prepare and file that patent application. That goes on file at the patent office. The patent office is a big government bureaucracy, and it will sit there at the patent office for, on average, 18 months to 2.5 years before a patent examiner picks it up and looks at it. Okay? So you're into it, $5,000 to $15,000 to file. Almost always your patent application will be rejected at least once. We do get first action allowances, but it's a rare occasion. The average right now at the patent office is like 2.5 rejections per patent application before it's abandoned or allowed. And basically the examiner types up a written document that says your invention is not patentable, and it will cite to usually prior patents and patent application publications, but they can rely on any publication in the world. They can rely on internet publications. Sometimes you get a rejection from an examiner and he's gone to the Wayback Machine and pulled up a website from in the past, and they'll use that to reject your application. And so then you have to respond, and you can argue with, and you can say, no, that you're not interpreting this reference right, or you're not understanding my claim, here's how it's different. Or you can narrow your claim, and instead of trying to claim this, you can shrink the scope of your claim so that now it's not reading on the prior art, right? Now it is new, but it's not, this isn't new, but this is new. So you amend your application. You can only amend your claims with language that's already in the application, so you can't introduce new matter to the application. That's why it's important to have a very long, thorough, detailed description of your invention, because that's the sandbox of tools that you're working in as you go to narrow your claims and try to avoid the prior art and get some claims granted. But every time you respond, you're going to be paying $1,500 to $3,500 to respond to that office action. Once you get to allowance, the PTO charges you allowance fees. There's some things the patent attorney has to do. You have some additional costs. So I usually tell people, if you want to pursue a patent application, you're looking at spending $20,000 over the course of about 5 years, with a big upfront loaded half of it. And, most of the work that we do is for companies that are continuously filing these patent applications. It's fun working with individual inventors, but I always tell an individual inventor, if you have $20,000 sitting in your pocket, would you invest it in a startup company? Okay? And they get a little hesitant because it's risky, right? Startup companies are risky. You might get a higher return, but more likely the odds say you're going to lose it. Investing in a patent application is even riskier than investing in a startup company. You're investing in an idea that if you're lucky, it might turn into a startup company, right? And the reality is that, I don't want to throw out numbers because I don't know what they're, but more than half of patents are worthless. They just are. They're lost money, sunk costs.
Sorry, but I'm a bit confused with the definition of patent, because first off, it says it has to be useful. So who's deciding what's useful?
The question is, who decides whether the invention is useful?
Right, and why have garbage then?
Yeah, okay. So it's true that the invention has to be useful, but the courts have interpreted that they put the bar so low that basically they don't even consider that question, right? They just say, basically the fact that you're willing to spend this money and pursue this patent application, it must be useful for something, or you wouldn't be here spending this money, okay? That's the bar. But whether it's novel and obvious, that's where all the bulk of the examination goes to. But you claim these new inventions, and every inventor thinks their invention is going to be they all believe in it, right? It's their invention. They think it's the golden child, right? Theirs is going to be the one that makes all the money. The reality is, the odds are against you. And if that's the case, why are these companies filing all these patent applications? And the reality is, if you file 100 patent applications a year, which some companies are filing thousands, 90% of them are going to be a waste of money, sunk costs. 10% will be extremely valuable, and they'll justify their costs and the cost of all the others. And then they'll generate, I use this example. I had one client, this is all public record, so I can speak about it, but they make drill bits. And Dr. Cutler said I do a lot of work in the synthetic diamond, right? Has anybody seen these diamond cutters, these synthetic diamond cutters that go on drill bits? Okay, they're made out of diamond. They're polycrystalline diamond, and it's like 95% diamond grains in the diamond table of the cutter, but the process that's used to make these cutters results in there being metal alloy in the interstitial spaces between the diamond grains. And so you're using these things downhole, you're drilling with the bit, the diamond gets heated up, right? And because of the thermal expansion, the coefficient thermal expansion difference, they get brittle and the diamond fails at like 800 C, right? Well, somebody in the industry figured out, this is now 25 years ago, that if you took an acid and you leached that alloy out of the interstitial spaces, just in the surface of the diamond table, that would make them more thermally stable, and you wouldn't have this problem with the diamond table disintegrating due to heat. And they filed a lot of patents on that, just etching the diamond table, thermally stable, compacts, and they started driving everybody out of the business. And our client basically came to us and said, look, we've got to do this or we're going to go out of business. And we said, well, our advice is you can't do this. You're going to get hit with a patent infringement lawsuit. They did it anyway. And so did everybody else in the industry. And they got sued. And, when I was a first-year associate, I was spending a lot of time looking for prior art. How do we invalidate these patents so that, this goes away? They got offered a settlement. They got a settlement offer for $30 million right out of the gate. And our client said, no, we're going to fight it. Because we found some good prior art. We felt pretty good that we could invalidate these patents if we went, we're ready to appeal up the court system. Well, they got through what's called claim construction, which is a thing that happens in litigation where, the parties are looking at the claims and they're reading them differently. The plaintiff is saying the claim means this and the defendant's saying the claim means that. So before you get to trial, you have a hearing and the judge says, I'm ruling that the claim means this, right? And a lot of times patent infringement cases will settle at that point because the parties know how it's going to end once the judge says what the claim means. They got an adverse ruling at claim construction and they ended up chickening out and they settled for $100 million, right? So that just gives you an idea as to how valuable patents can be. Oh, and since then, we've been paying royalties. This company has made billions of dollars off these patents. So, patents can be extremely, extremely valuable, but most of them are not worth anything. All right, side note. Patent jeopardy. Anybody know who this is? Einstein. That's a picture of Einstein when he was a patent examiner in Switzerland. Okay, so you have a patent, but do you really? Okay, I just explained, I mentioned a minute ago that when you sue a defendant for infringing your patent, they're going to counterclaim and allege that all your claims are invalid. It's just par for the course. It happens in every case. Okay, there is a presumption of validity that basically in the litigation, okay, the patent examiner, when he's examining your application, he is looking at the prior art and he makes of record everything that he looked at. And I don't want to try and pull that patent back up, but on the front of Dr. Cutler's patents, you can see every document that the examiner looked at before he decided to grant those claims, okay? So under the law, those claims are presumed valid over that prior art that the examiner considered. What does that mean? That means that if somebody's going to argue that the claims are invalid based on that prior art, it's not, well, when the judge is looking at it, he's not going to say, is it more likely than not that these claims are invalid based on the prior art? The standard is clear and convincing evidence, right? It is so clear and convincing. The evidence clearly and convincingly shows that this examiner missed something in this document, right? They clearly did not see this or they would have rejected this, okay? But there is no presumption of validity based on prior art that the examiner did not consider, okay? So if the defendant challenges the validity of the claims based on prior art that is not listed on the front of the patent, the standard of proof is not clear and convincing, it's just preponderance of the evidence, which means it's more likely than not. Like 51% claims look invalid based on this prior art, okay? So what is the body of prior art? It's any publication anywhere in the world in any language, okay? These examiners are allotted by the patent office like 3 hours to do an office action, right? They do not have the time or the ability to search all the relevant prior art. They're very good at what they do, right? They can usually find pretty good prior art pretty fast, but they're not scouring the entire body of prior art in the world. And so the reality is, when you get a patent granted, you should think of it as a license to initiate a lawsuit and prove to the court that you have a patentable invention. And the defendant is going to be spending a lot of time and money searching for prior art and arguing that you don't have a valid claim. So a lot of your claims get invalidated during litigation. Okay. So what are the economics of litigation? You thought it was expensive to get a patent, okay? To enforce a patent, just to file a lawsuit and enforce your patent against an infringer. I mentioned that this claim construction process where the judge rules how he's interpreting the claims. Okay, that's called a claim construction hearing. Discovery is just evidence gathering. Okay, so you initiate your lawsuit, and there's all these stages of litigation that happen. You have this claim construction hearing, and at that point, a lot of times parties settle. So just to get through that is going to cost you $250,000 to $500,000. If you go to trial, $500,000 to $750,000. So you can see how this eats up the cost, the potential damages that you recover. And as the money at stake goes up, the costs of litigation go up because the stakes are higher. You hire more lawyers. Everybody's thinking about that. You get a team of lawyers trying to figure out how are we going to, establish that these claims are valid, that they're infringing. It gets very, very expensive. Who here has enough money to enforce a patent? I don't. So that raises the question, if you and I are unable to get a patent for ourselves and sue other companies, is this system good for us? Okay, this is not a new debate. In the 19th century, Mark Twain wrote, "A country without a patent office and good patent laws was just a crab and couldn't travel any way but sideways or backwards." This is from a Supreme Court case in the mid-20th century. One of the justices said, "The only patent that is valid is one which this Supreme Court has not been able to get its hands on," meaning, we've got all these invalid patents. How can all these invalid patents be good for the system, right? What are we doing here? This has been a major debate, and I signed up to be a patent attorney just when this became the biggest debate in the history of time. Okay, here you can see Google, founded in 1998. That first year, they filed 250 patent applications. At this point, they're filing over 4,000 patent applications every year. Okay, and in the early 2010s, Google and a lot of these Silicon Valley tech giants started lobbying Congress. Right here, my daughter was showing me the Bing AI image generator. I asked it to generate a cartoon depiction of a company progressing through time from a startup to an industry giant. Okay, so it's a bad cartoon. There's a lot of work to do on AI. But down here, startup company. Up here, industry giant, okay? Well, Google has power in the marketplace. They have extreme power in the marketplace. Apple does too. Microsoft. They have extreme power in the marketplace. But it's not because of their IP at this point. At this point. At this point, it's a necessary expense that they have to engage in, or they will slowly start to lose that market power, right? So, but when Google was down here, and when Google was filing 250 patents down here, you better believe that they thought that those patents were important to them, right? And all the way up until they started, getting 2013 is in between the purple and the blue. At that time, they started to go, okay, these patents aren't very great for us, right? These are just, we can just use our money to push people out of the market. We can just buy the companies that we want to buy. We don't need these patents. And not only were they spending money, right? They don't like spending money on things that don't really give them, added value to their market power. But Google gets hit with lawsuits, right? They get sued for patent infringement. Now they're spending money defending patent assertions against them, right? And so Google started, and these other industry giants started lobbying Congress in early 2010s. And this ultimately resulted in Congress overhauling the entire patent system in 2013. It was part of what's called the America Invents Act, okay? The year prior, let's see, is it the year prior or the year the AIA was passed, they spent $18 million lobbying Congress to change the laws. The year after, it dropped to $1 million, okay? So what did they do? What were they changing? At the time, as a patent attorney working through this and seeing this in the news, we didn't really know how it was going to change the industry. It was really unsettling, right? I remember my uncle calling me on the phone and he's saying, "Are you looking at the news? Are you worried about your career path?" These were two articles that spring of 2013, I was going to pull this up, but I don't have the internet, but basically you saw a lot of news articles, probably funded propaganda, right? The patent system is bad, it's stifling innovation, this is all bad for industry, the patent system has outlived its useful life. And then, you have a counter narrative of, no, we still need this. We still need this. And the reality is that the small and medium-sized companies, the startups, the medium-sized companies, they value their IP. It's critical to them because they would just be driven out of the industry by the industry giants, right? But once you become an industry giant, the patent system becomes a little bit of a thorn in your side. It's kind of funny. Here's another AI-generated image. Raise your hand if you have not heard the term patent troll. You haven't heard it? Okay, well, this was part of the propaganda, okay, of that whole information narrative. They would refer to these small, basically individuals, or there were these companies that, we call them, now we don't refer to them as trolls, right? We refer to them as non-practicing entities. Here's an AI-generated image. I was trying to show an individual inventor engineer talking to the Google executive saying, I've got a patent you're infringing, just pay me a royalty, right? What happens? If you have an invention, you get a patent, Google's infringing it, you send them a letter, what is Google going to do? Yeah, come talk to us about it. We'll write you out a check. No, they're not going to do that, right? They know what it costs to enforce that patent, and they know that you don't have the money to do it. So they just ignore you. Your letter comes in, put it in the shredder, right? Well, what that did, when companies fail to respect patents because of the cost of litigation and they think they're not going to get sued, it creates a market for people with money. Oh, you individual inventor, you don't have the money to hold Google to the fire, but I do. So why don't you assign your patent to me and I will sue them, and then I'll give you some royalties and pay you. And we call these non-practicing entities. There's companies out there that all they do is acquire patents from individual inventors or small companies, or sometimes big companies spin off their portfolios, right? Segments of their portfolios. And these companies will just acquire the IP and enforce the IP, right? Well, this was a thorn in the side of these companies, and they started calling these companies trolls. These are just patent trolls, right? They're not building anything or selling anything in the marketplace, and they tried to paint them in a very negative light. But the reality is, if these big companies would have just respected the IP of the inventors, there would be no need for a non-practicing entity, right? So we refer to them as NPEs. I don't believe in patent trolls. There are people that make baseless assertions of patents, right? It's clear that you don't infringe, but they'll try to shake you down, right? Those are baseless claims. They get made by people, individual inventors, small companies, medium-sized companies, large companies. There's bad actors across the full spectrum, right? Those people are bad actors, but just non-practicing entities that are not making baseless claims, they're not bad actors. They have a legitimate claim under the law. So you don't hear this term patent troll anymore. It was all over in 2013. So what did Google and these big companies accomplish by essentially overhauling the patent laws? The major thing that changed was we went from a first to invent to a first to file system, okay? And when I first started practicing, we were in the first to invent regime. And basically, if you filed a patent application, and you'd think this would never happen, but it happens quite frequently. Somebody else makes the same invention just a few months before you or a few months after you. It happens quite commonly because in a certain area of industry, everybody has the same problem. They're all trying to solve the same problems, right? And under the old rule, the examiner would reject the later filed application because they just presume the invention was made on the date the application was filed if there's no evidence to the contrary. But if you could present evidence and say, well, I filed my application here, but I actually invented it 12 months earlier, right? And here's my invention disclosure. Here's my documents I filled out. They're dated, signed by a witness. You could prove, if you could prove with evidence that you invented it first, you would get the patent even though you filed second, right? Everywhere else in the world at that time was first to file. So it just cleans up the litigation. It simplifies the process, but you may have been the first inventor, but if you didn't file first, you're not going to get your patent for it. And I remember when I first started practicing, we would get an invention disclosure from our clients, and I'd have 6 files of patent applications to draft sitting on my desk. This is pre-digital world. And, I'd get a patent application, and we'd file it 6 months later. There was no rush, right? Because we had it documented when the invention was made. There was really no rush to get that patent application filed. When they switched to first to file, it was like we thought the world was going to end, because now I've got to turn this thing around in 2 weeks. We're not doing it in 2 weeks at this point, but we thought we were going to get pressure from our clients to just file like this. And now the typical turnaround time, we tell our clients 30 days, 45 days. It hasn't been as bad as we thought it was going to be. The other thing that they did, which at the time, we didn't know what this was going to mean in the real world, how it was going to affect our day-to-day life as patent attorneys and inventors. But they established mechanisms for challenging the validity at the patent office, okay? So you have to remember that in the US, we have this jury system, right? They're all jury trials, and we believe very strongly in juries, right? And so at trial, right, the juries were learning about this technology and these patents, and they're not engineers or scientists. Their eyes are glazing over. They don't know, right? And so a lot of the outcomes was very attorney dependent, right? Or your expert witness, how persuasive were they? And in other countries, patents are treated separately. They have a patent court, and the judges are all engineers and scientists, right? And lawyers. But so they created this system at the patent office where you can challenge the validity of the patents at the patent office rather than in court. And they put laws in place that said, if you get sued for infringing a patent, you can go to the patent office and challenge the validity of the patent at the patent office if you do that within 1 year. And then the litigation will be stayed and put on hold until the patent office rules on the validity of the patents, right? And so essentially, in any patent enforcement lawsuit today, I shouldn't say any, but most, the plaintiff will file their lawsuit, allege infringement, and the defendants very, very commonly will immediately run to the patent office and challenge the validity of the patents at the patent office and request that the judge stay the case. Now, it's very clear from the laws and the legislative history that Congress intended that the judges would always automatically stay the case pending the outcome of the proceedings of the patent office. But judges are very independent people, and they find ways to try and skirt it. And not all courts are doing that at this point. There's a couple courts in Texas that are very plaintiff-favorable jurisdictions, and the judges try to move very, very quickly in the patent enforcement case. And they there's a lot of patent enforcement proceedings filed down in Texas for that reason, and they don't always stay the case if you go to the patent office, but very commonly they do. In hindsight, at that point, I didn't know what to think of it all, right? Was this good or bad for the system? I don't know. Now, in today's world, I think it's good. I think it's good because the reality is patent examiners just don't have the time to do a thorough examination. They do a cursory preliminary examination. And the reality is that a lot of these patent claims that are out there in force pending right now are invalid, okay? And so it is a good thing to provide a mechanism to spend all the parties' resources figuring out what claims are valid at the patent office in front of scientists and engineers and people who understand the technology and understand the prior art, understand the patent system, They know what novelty means. They know what it means to be obvious or not obvious, and deal with the validity. And then once you know which claims are valid, go back to the court and deal with infringement. Let the jury decide if they're infringing. So in hindsight, I don't think it's a bad thing. We do quite a bit of work now at the patent office instead of court, and I enjoy that stuff as well. I mentioned the stay in the litigation here. I wanted to show you a design patent. I can't really. Is anybody familiar with design patents here? Because I don't have the internet, I can't pull this up. But so utility patents are meant to protect useful inventions, right? So new widgets, new machines, new compositions of matter. They don't protect creative aesthetics, right? But a design patent protects the way something looks. It's looks and appearance. It's more similar to like a trademark, right? You're protecting the style of your product. If you've created something that has arguably an artistic aspect to it, right? It's more like copyright. They don't even call these design patents outside the U.S. They call them design registrations. But essentially what you do is you just depict your product in drawings, and that's all that it is drawings. There is a description of the figures. I don't think I have that here, but there would be a description that just says, figure 3 is a plan view of a phone showing my new design, right? This is Apple's design patent for the iPhone. I'm an Android guy, but I don't know does anybody remember when Apple sued Samsung? Apple sued Samsung for infringing this design patent. And the way a design patent works is you show the aspect of your design that you want to protect in solid lines. And everything else that's not part of the claimed design is shown in broken lines. So you can see here that what they patented was basically this bevel surface and a round home button. And that was the design patent. Nothing on the back is covered. It was just that bevel. And Apple sued Samsung, alleged infringement of this design patent. They got a judgment. Anybody want to take a guess at the damages? Throw out a number. Yeah, I think it was over $1 billion. I've got it on the next slide here. But I thought this would be fun here. Top 10 patent infringement judgments, this is just in the US. The 10th was in 1991, Polaroid versus Kodak, $925 million. $1 billion. $1.04 billion, that's the one we just talked about. Carnegie Mellon University versus Marvel Technology, 1.17, 1.2, 1.5 billion, 1.6, 2.1 billion, Intel versus VLSI, 2.1 billion, Idenix versus Gilead Sciences, 2.54 billion. So this is why, companies are still filing patents. And, but in reality, the reality is that most of these are the big industry giants, right? They're the ones that were complaining about the patent system in the early 2010s. The patent system really serves the startup companies and the medium-sized companies, and it serves them very well. I've always told, and I deal with all different sizes of companies, and it's very common for patent attorneys to graduate from law school. They go to a firm and they work for a firm doing patents, prosecution and enforcement for their clients, and then, it's kind of a grind, life as a patent attorney, right? We're in our office reading and writing all day, and people get burned out, and they go in-house and they become in-house patent attorneys, excuse me. And I've got several friends that went down that path, and I've always told them, if I ever go in-house, I will not go to a big corporate giant because they just see their patents like a necessary evil. It's just a commodity. You're an expense. You're not an asset to them. I would go to a small, medium-sized company who sees their IP and their patents as a critical asset of the company. They see you as an asset, right? An investment. I would go work for one of those companies. And I would also work for a private company, not a public one, but we'll talk about that reasons why later. But that's the last slide that I've got. Got a couple interesting stories. So one of our clients is in the gaming industry, and there is this rule at the patent office that when you apply for a patent, you have a duty of disclosure to tell the patent office the most relevant prior art. If you're aware of it, you have no obligation to go do a search for prior art, right? But the patent office has a rule that if you're aware of material prior art, you have to disclose it. We submit these forms, they're called invention disclosure statements, where you list the prior art and give it to the examiner and he looks at it. And then it ends up printed on the front of the patent. Right? Well, if you are in litigation, one defense that the defendant has is that you didn't comply with the duty of disclosure. You knew about this prior art, you didn't tell the examiner, and your patent's invalid based on this prior art, and by the way, you committed fraud on the patent office because you didn't comply with the duty of disclosure and submit the prior art. And if the court determines that that is true, you committed fraud on the patent office, didn't submit information, material information of which you were aware, the patent is held unenforceable, okay? So this client of ours, they made card shufflers. They sold them to casinos. So when you're playing blackjack, you have this card shuffler on the table, you put your cards in, shuffles all the cards, spits them out, and they had a legitimate patent monopoly, right? It was legitimate. They had these patents. There were no competitors. Everybody kept trying to creep into the market. They'd sue them, buy them, they would just quash them. And these machines, they'd sell these machines for like $30,000, $40,000, right? They're very expensive machines. But inventors would come up with simpler, low-cost alternatives, right? And so these small competitors, there was one company out of Taiwan that came into the US with a $10,000 card shuffler instead of a $40,000 card shuffler. Well, our client sued them. And by the way, we were not involved in prosecuting the patents, and we didn't handle the litigation because they hired a big, expensive law firm to handle a multi-billion-dollar lawsuit, not some firm in Salt Lake City. But we were representing them in patent matters at the time, getting them new patents, and so we were doing some litigation support. So we're kind of on the sidelines, involved enough to see what's going on. Well, this person that worked there, sweetest lady ever, she was so afraid that she was in-house at this company. And when they were prosecuting these patents, she was so afraid that she wasn't complying with the duty of disclosure that she was just submitting all this art to the patent office, right? And the defendants came back, and after they were basically driven out of business by the patent litigation, they convinced a firm to file a lawsuit and allege that an antitrust claim. They basically said, you buried the relevant prior art by submitting all this information to the examiner. You gave the examiner more than he could chew, and you hid the relevant prior art in that invention disclosure statement. And you committed fraud on the patent office. And then you got a patent that you knew was invalid, and then you went out in the industry and started suing people with a patent that you knew was invalid. And they won that antitrust lawsuit, and my client had to pay $1 billion. So, yeah, it was unbelievable to me. And I know, I truly believe that she was not committing fraud on the patent office. She was just afraid of not complying with the duty of disclosure, because every patent attorney knows that if you get patents for people and then they get litigated, you're going to get accused of inequitable conduct because every defendant does it. They look for any way possible to challenge the validity of the patent and get the judge to rule the patent's invalid or unenforceable. So, we get used to being deposed and getting asked about the prior, you knew about this? Yeah, I submitted, You're always on the defense. It's not fun. Any questions? Yes?
What sort of rights do contributors have on a patent? Like if there's multiple contributors to a patent, what can they do in terms of licensing?
Yeah. So the question is, how do you deal with multiple inventors and can there be multiple owners? The answer is yes. Let me pull up Dr. Cutler's patent here. I've got to stop the presentation here. So the law starts with the presumption that the inventor, whoever invented the invention, owns the patent, okay? And you can have joint inventors, right? And the law, this is all very thoroughly spelled out in the laws, what it means to be a joint inventor. Who is a joint inventor, right? Engineers are team players. It's very common. And by the way, it used to be that if the inventorship was wrong, your patent wasn't enforceable until you corrected it. And this changed as part of the AIA when they totally overhauled the laws. But it used to be that if you didn't get inventorship correct, and then you sued somebody, and the defendant, they get to depose everybody and talk to everybody under oath. And it turns out there was another guy down the hall who was an inventor and you didn't name him, okay, then you have to go fix that at the patent office. And by the way, you're not entitled to any damages until it's corrected. So you file a lawsuit to allege infringement, you're asking for all these damages for these past acts. Now all those damages went away and all you have is moving forward from when you fixed the patent, okay? So to be an inventor, you have to have contributed to conception of the invention. And we distinguish people who contribute to conception of the invention from people who just assisted in reducing the invention to practice. Okay, so a common example that I use, somebody has an idea, I want to make this thing, all right? You walk down, you don't do the CAD design, you don't do the CAD drafting. So you walk down the hall to the CAD drafter and you say, here's my idea, I want to do this thing, can you draw it up for me? The CAD drafter draws it up. Is the CAD drafter an inventor? No, because he just reduced the invention to practice. But commonly, the CAD drafter, as he's drafting it up, says, hey, this is a pretty good idea, but I think I can tweak it a little bit. I think we should put this feature on it, or tweak it a little bit. All of a sudden, if that change ends up in the patent claims, then he is an inventor, okay? Now, and here's where it gets into state law. Most states have passed state laws that say that if you're an employee of a company, you're obligated to assign your inventions made while you're an employee that relate to the technology of your employment, you're obligated to assign that to your employer. So just by law, when you're an employee and you have an invention, you're obligated at that instant to assign it to the company, right? So every inventor, Dr. Cutler, would have executed an assignment document granting his ownership of this invention to Ceramatech. And then that gets recorded at the patent office. You can look up any patent at the patent office and you can see the chain of title. It went from the inventors to this company, and then they transferred to this company. You can see who's licensing it sometimes. Okay, that brings up another question though. Yes?
Oh, no, go ahead. I thought you were done.
Okay. What if there's two employees of different companies, right? It's very, very common for companies to work with other companies developing technology, right? We have joint development agreements. I advise clients with respect to joint development agreements all the time. I always tell them, these start well, everybody's best friends. When you sign this agreement, you're everybody's best friends. This is a great idea. You guys are going to solve the world together. They always end, and when they end, they don't usually end very well. And they're not friends after they end, usually. So if two employees of two different companies make an invention, unless it's spelled out in a joint development agreement, then they will assign their rights to both companies. And it's very common to see patents with two companies here. And in the absence of an agreement, to the contrary, each one of those companies has a full ownership of the patent and can enforce it with no obligation to the other one, right? So if there was another company here, Ceramatech could go grant licenses in the industry and the other company could not object, right? And they could sue somebody and get damages, and they don't owe any obligation to the other company, right? So it's very, very critical. One thing I would tell a new engineer, when you start working with other companies, you have to have the hard discussions about IP. What's going to happen with these inventions that we make as we work together before you start inventing, right? You have to execute an agreement that says, okay, if we have joint inventions, we're going to own these and you're going to own those, or we're going to create a third party that we both own 50-50 and we're going to put it in that company. You know, you got to think it through and figure it out and basically reach an agreement before you start inventing. It's very, very common that my clients will call me and say, hey, we've been working with this company so-and-so and we've got an invention, and then it's like, have you thought through who's going to own this invention that you just made? Because, you know, as it stands right now, you've got a full ownership and they've got a full ownership, and it's harder to have that conversation after you've already made inventions. Did you have a question?
I did. So when you're doing things like patent searches, not you necessarily, but just
Yeah.
any individual, right? I understand like non-disclosure, right? So talking to someone, and that could be a CAD person or someone helping you with research, right? Researching for you. That you would want to have that done in case there are any alterations to the design or in case they point out anything about the idea, right? Here, I know at the University of Utah, here at the library, they have a whole patent expertise, right? Like a connection. There's librarians here who work directly with the patent office. And as far as patent searching, if you go to those individuals, right, at the library here who work with the patent office, is there automatic confidentiality in that when you're talking to them about your ideas that you're needing to research, right? You're needing to comb through user expertise to comb through files online and make sure, you know, that you have a valid novel idea, right? Is there confidentiality in that due to the nature of your job, or is that something where you would still, which then it gets complicated, right? You're going to university, having them, hey, sign this non-disclosure. How does that make sense?
I mean, you know, dealing with the library here at the university, yeah, I mean, yeah, you would want an NDA, but what I usually tell my clients is that an NDA, great, right? They're obligated not to disclose your information, but it is not. Ideally, you do not want to disclose your invention to a third party just under an NDA.
Right.
There's too many ways that can go south, right? You know, what if they see your invention and they don't disclose it, but they invent an improvement?
Right. So I know that, and I appreciate that response. I know that sometimes when you have someone sign something, you can actually, and you would know more about this than me, kind of clarify that, like as a prerequisite to them signing. I don't know if that's fully true or not. Are there any positions, like any jobs, right, besides a lawyer like yourself, obviously, where there's confidentiality, right? You're not going to take those ideas. So I guess for myself, that's what I'm wondering is if I go to a library, right, and that library has individuals who work with the patent office directly, and I'm asking them for help to search.
There's no obligation of confidentiality.
There's no, okay, gotcha. Thank you so
I mean,
much.
in the absence of a written agreement.
Okay.
Yeah.
Okay.
Yes.
Okay, I would invite those who have questions to come up and talk with Jeff Gunn. Let's give Jeff Gunn a great.
Thanks for having me.